All right, welcome to The Explainer. Now, if you are prepping for those Queensland bar exams, or you're just looking to sharpen up your litigation skills, you're going to want to pay close attention. Today, we're getting into a really powerful, super practical set of tools that you absolutely need to know. We're talking about the powers of preservation under Chapter 8 of the Uniform Civil Procedure Rules.
So here's how we're going to break it down. First, we'll look at the kind of problem this rule solves. Then, we'll introduce your main tool. That's Rule 250. After that, we'll get into the specifics, how you choose the right gateway to use it, what the order actually lets you do, and then we'll hit some pro tips and crucial warnings you'll need for the exams. And by the end, you'll have this essential piece of the UCPR down cold.
Okay, so let's set the scene. Let's start with a really classic scenario, one that you will see time and time again, both in practice and, you guessed it, in your exam questions. Think about it. Your client's entire case could just vanish if that key piece of evidence gets tampered with or disappears. You have to get in there, you need to see it, and you need to do it now. This isn't just some logistical headache, it's a massive strategic challenge. But thankfully, the UCPR gives us a really powerful answer.
So, let's talk about the solution. The main weapon in your arsenal, the rule you really need to commit to memory, is right there in Chapter 8, Part 1 of the UCPR.
Say it out loud. Rule 250. This is your go-to. It gives the court the clear, explicit power to make orders to inspect, to hold, or to preserve property that is fundamental to a case. This rule, Rule 250, is the key that's going to unlock the door to the evidence you desperately need. Now here's where it gets interesting. To get an order under Rule 250, you actually have two different paths, two gateways you can go through to convince a judge. And understanding which one to use is absolutely fundamental to your success. Okay, so you've got to get this difference burned into your brain. Rule 250, Subrule 1, Paragraph A, versus Rule 250, Subrule 1, Paragraph B. They are not a sequence, they are alternative sources of power. So Paragraph A is your gateway when the property itself is what the whole fight is about. Like a case over who owns a specific car. The car is central. But Paragraph B is for when the property isn't the core issue, but you have to inspect it as evidence to decide something else. And this quote from Wilson Ceramics just nails the distinction. As Kefford DCJ explains, if you're using Gateway A, the property being central to the case is enough. But, and this is key, if you use Gateway B, because that property is just for evidence, you have to meet a higher bar. You have to prove to the court that the inspection is necessary. All right, you've picked your gateway, either A or B. You've made your case to the judge, so what can the order actually let you do? Well, the scope of these powers is seriously impressive. Under Rule 250, Subrule 3, that's 2503, the court can sign off on a whole range of actions. We're not just talking about having a quick look. The order can let you enter a property, take samples for testing, make detailed observations, take photos and videos, and even conduct experiments on the thing itself. You can see just how powerful this is for building your case. And here is another absolutely critical point, especially for your exams. Rule 250, Subrule 2, extends the court's power way beyond just the parties involved in the case. So if that crucial piece of evidence is sitting in some third party's garage, someone who's a total stranger to the lawsuit, the court can still make an order against them. Okay, let's get into the more advanced stuff. These are the kinds of details that separate the good barristers from the great ones and, the kind of things that exam questions love to test. First up, what do we actually mean by property? Well, the definition in the Acts Interpretation Act is huge. It's incredibly broad. It covers pretty much any kind of legal or equitable interest you can imagine. But the courts have been asked to push this definition to its absolute limits.
And this is where the case law gets really fascinating. Can a court actually make a preservation order over human tissue? The answer might just surprise you.
The answer is yes. In Roche v. Douglas, the court decided that tissue samples taken from a deceased person were, in fact, property for the purpose of a court order. This allowed for DNA testing in a paternity dispute. Yes, again. In the Basley case, a widow wanted to stop an IVF clinic from destroying her deceased husband's stored sperm. The court stepped in and made a preservation order under Rule 250, finding that the sperm could be classified as property. And a third time, yes. In James v. Seltsam, an order was made for the testing of a plaintiff's lung that had been surgically removed. This was in a personal injury case, and the order was made even though the testing might actually destroy the lung. So the big takeaway here is that property is a much, much wider concept than you might think at first.
Now, A massive, massive warning. Put a big red circle around this in your notes because this is a classic exam trap. You absolutely cannot use Rule 250 during the pre-court process, under the Personal Injuries Proceedings Act or PIPA.
And the reason why comes straight from the Court of Appeal in Day v. Woolworths. The court was crystal clear. A PIPA claim is just a claim. It doesn't become a proceeding in the eyes of the UCPR until you have actually filed that claim and statement of claim with the court registry. So no proceeding, no power under Rule 250. It's that simple.
And one last thing. Let's go back to that higher bar for our second gateway, Rule 250, Subrule 1, Paragraph B. What does necessary really mean? Well, the test from the Hartley case is that an inspection is necessary if you can show a good reason to think that without it, your client will be stopped from getting a just outcome. It's a high standard to meet. Just being convenient isn't going to cut it.
Okay, let's wrap this up and lock it all in. We've covered a lot of detail, but it really boils down to just a few essential points that you need for your exams and for your practice down the road.
So here's your checklist. Number 1, Rule 250 is your key tool. 2, choose the right gateway under Subrule 1. Is the property central under A, or is the inspection necessary under B? 3, remember the huge range of powers you get under Subrule 3. 4, appreciate just how broad the definition of property really is thanks to that case law. And number 5, never ever forget the PIPA limitation. Get those 5 points down and you have mastered this tool.
And really, this is the main thing I want you to take away today. Knowing the rule exists is only half the battle. The real skill of an advocate is in applying it. The power of Rule 250 isn't just in being able to recite it, it's about building that persuasive argument, backing it up with evidence, and showing the court exactly why the interests of justice demand that you get to see what's behind that closed door.